To the regular meeting of the Woodbury Zoning Commission for Tuesday, January the 10th. Seated for the regular meeting are Commissioners Overton, Clark, Cosgrove, Green, and Teets. According to our agenda, the first item is to move to go into executive session, which I hope will be short. We've located a room upstairs in this building where we can remove ourselves rather than have the public leave this room. So the first item is for me to move that we go into executive session.
Before we go, Mr. Chairman...
there's a motion on the floor, and it's been seconded. Discussion on the motion to move.
May I speak?
If it's in discussion...
It is discussion. I have researched the state statutes on executive session.
Yep.
1-200, Section 6, which you can review a copy of. I would like to know which of the 5 items explicitly mentioned in here you are invoking to go into executive session, because pursuant to law, you have to have a reason to go into executive session. I have them here if you'd like to review them, but I have it all copied, because my assertion at the last meeting that this is illegal is, in fact, I have researched it, and that is the case.
I appreciate your bringing that up, Sean. And for that very reason, I did seek the opinion of our Attorney Roberts and Howard and Sage, and to go into executive session to discuss privileged documents not subject to disclosure is a valid reason for going into executive session.
Only if the Commission votes to keep them privileged, which the Commission has not seen them.
Right.
So we're going to executive session on something. I also have an article from January 4th, 2012, the Woodbury Republican. Your claim that this is under litigation is disputed by Tom Hennick, who is the chairman of the Commission of the Freedom of Information Commission. And it says right here in the article, quote, exceptions for legal strategy and negotiations regarding pending cases. Discussions that don't meet a narrow set of criteria for discussion in private must occur during public session according to the statutes. And I say again here, I have the statutes here. We have, I'd like to know which reason, because if we are found at a Freedom of Information hearing to have been in an illegal meeting, we have a problem on our hands where the Commission members can be fined personally. So
Sean,
I'd like to see which item under executive session. I have them here. You're welcome to review it. I'd like to know which one you are invoking in going in executive session. That's all I'm asking for. I have the document here. It's very simple. There's only 5 possible items.
Sean, with respect, your legal opinion isn't going to carry as much weight as the legal opinion I got from the attorney.
Where is your legal opinion?
I called him.
I don't care about calling him. Where's the paperwork?
No, I called him and asked him.
Well, we don't trust what you
Is
said,
it okay?
You've said things to us before that weren't true.
Again, I have here, you don't have any documentation. I have documentation. I'd like to read it in the record. Executive sessions, this is state statute 1-200, and under section 6. I got this, printed this from the state statutes on the web, from the state of Connecticut. Executive sessions means a meeting of a public agency at which the public is excluded from one or more of the following purposes. That states there has to be a reason. Item A, discussion concerning the appointment, employment, performance, evaluation, health, or dismissal of a public officer or employee, provided such individual may require that discussion be held at an open meeting. We're discussing a legal opinion, we're not discussing employees, so that's not it. B, strategy and negotiations with respect to pending claims or pending litigation to which the public agency or a member thereof, because of the member's conduct as a member of such agency, is party until such litigation or claim has been finally adjudicated or otherwise settled. I have no knowledge of any lawsuit against the town regarding anything relating to the matters in the legal opinion, so it's not B. Matter C, it says matters concerning security strategy or the deployment of security personnel or devices affecting public security. That doesn't qualify. Item D, discussion of the selection of a site or the lease, sale, or purchase of real estate by a political subdivision of the state when Publicity regarding such site, lease, sale, purchase, or construction would cause a likelihood of increased price until such time that all the property has been acquired or all proceedings or transactions concerning the same have been terminated or abandoned. That doesn't qualify. Item E, discussion of any matter which would result in the disclosure of public records or the information contained therein described in subsection B of section 1-210, and that's 6 pages long. If you would like, I'd be more than happy to read each of those.
And that mainly concerns security.
Yep, there are 25 sets there with subsets of it. It's dealing with security.
Police and security.
Yeah, if we were reviewing plans of a police station under zoning, we could do that because there's a security reason to keep that private. So all I'm asking is that we simply disclose what our legally allowed reason is to go into executive session, because we've already been through one Freedom of Information hearing, and I don't want to go back.
Do any of the commissioners need any more information from alternate Mark? That being the case, I'll call the question. All those in favor signify by saying aye.
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 Nay.
Opposed?
Opposed. I'm opposed to it.
You're
I
not,
want to
you're not seated. But your comments noted. So the ayes are 4, the nays are 1, and there are no abstentions. So
Who are the ayes?
well, the nay is Chuck, so the ayes are the other 4.
Okay, thank you.
So we'll move to executive session. We're going to go upstairs. Please feel free to remain seated. We will be back.
We all got it.
Yes.
Next step away. Sure, I should go up there with a freaking tape recorder.